The lecture series was launched in 2011 in order to focus public engagement with the key themes of social justice which concerned Krystal Macmillan during her lifetime and which the school continues to work on today. These themes include human rights, gender inequality, peace and conflict resolution, and global citizenship. Tonight it's my pleasure to introduce this year's Chrystal Macmillan Lecturer, the distinguished political scientist Professor Louise Chappell, who's going to give a lecture entitled 10 Years On, Is the International Criminal Court Delivering for Women? Professor Chappell is the Social and Political Science Institute of Advanced Studies in the Humanities visiting fellow, sorry about that, visiting, it actually says SPSS-IASH visiting fellow in front of me, but I thought that might be even more mystifying, at the University of Edinburgh. She's here till the end of the year. She's been here since December. She's Professor in the School of Social Sciences and a member of the Australian Human Rights Centre at the University of New South Wales, where she's just completing a 4-year Australian Research Council Future Fellowship on the gender mandate of the International Criminal Court. And this work's involved tracing the implementation of the ICC's innovative gender provisions across each aspect of the court's operations: the judiciary, the office of the prosecutor, and the registry. Louise Chappell has published a number of research articles as well as media and blog commentaries in the area, and is in the process of completing a monograph on the ICC for OUP. Last year, with colleagues at the Australian Human Rights Centre, she convened a conference called Justice for All, the International Criminal Court, a 10-year review. And this event brought together all the major ICC officials and diplomats in dialogue with jurists, scholars, and human rights organisations. When the school moved to its current location in 2008, we were told that we couldn't take civil society with us in the form of Adam Ferguson, little realising that he would be abolished by the business school a few years later. And we had to look for a name for our building. We decided to name the building after a remarkable woman, Krystal Mcmillan, and we named it in honour of her dedication to peace and women's rights, and as a symbol of the school's academic interest in gender equality, international politics, social movements, and human rights. Krystal Macmillan, who was born in 1872, died in 1937, was the first female science graduate of the University of Edinburgh. She graduated in 1896. She was a suffragist and co-founder of the Women's International League for Peace and Freedom. She made history again in 1908 as the first woman to plead a case before the House of Lords, where she argued for female university graduates to have the right to vote. She was a prominent voice in the women's rights movements throughout her life, campaigning on a number of issues. She was a close associate of Millicent Fawcett in the UK and was secretary of the International Women's Suffrage Alliance from 1913 to 1920. She is one of the organisers of the International Congress of Women in The Hague in 1915 and was a member of the delegation from that Congress to present proposals to heads of neutral states for halting the First World War. Following the armistice, she was a delegate at the Paris Peace Conference, which was held in 1919. She was called to the English bar in 1924, again as one of the first group of women admitted, and developed a distinctive career as to what we might now call a human rights lawyer and global activist. And there's stuff out there in the foyer which you can have a look at afterwards if you're interested in more information on Krystal Macmillan. In today's lecture, Professor Chappell will be reflecting upon the first decade of the ICC's operation and evaluating the extent to which it's lived up to its promise to promote gender justice. The ICC has an innovative mandate that includes the most advanced articulation ever under international law of crimes of sexual and gender-based violence, and groundbreaking procedures to allow the victims of those crimes to seek redress. Now, Professor Chappell will speak for about 50 minutes, and then we'll have a response from our colleague, Professor Christine Bell, who's Professor of Constitutional Law here at the University of Respond. Christine will respond briefly. There won't be a formal Q&A session after that, but there'll be a chance, there'll be a reception outside, and there'll be a chance for anybody who wants to engage to take their turn to engage with either Christine Bell or Louise herself, of course, or indeed anyone else that you meet here who looks somewhat interesting. So with that, I'll hand over to you.
Well, many thanks, Jonathan, for those kind words. There are some really wonderful things about an academic life, and right now I'm enjoying one of them, and that is to have the opportunity to travel to a new place and to meet and engage with new people. And I feel very fortunate to be here at the University of Edinburgh and have been touched by the very warm welcome I've received from members of the School of Social Sciences and Political Science, as well as Professor Jolyon Mitchell, Anthea Taylor and my colleagues from the Institute for the Advanced Studies in the Humanities, where I'm based. And I thank them all for making my time here so enjoyable. As anyone who's ever organised one of these events, and I know I've done a few, it takes a lot of work to put them into place, and I'd like to acknowledge the efforts of Andrea Birdsall and Jeevan Sharma and others on the Krystal Macmillan Steering Committee for arranging tonight's lecture. I'd also like to thank Christine Bell for so generously agreeing to be the respondent for my talk tonight, and for also showing my family and I such warm hospitality since I've been here in Edinburgh. Another huge bonus of academic life is meeting people who inspire your work. And for me, one of those people is Professor Fiona Mccoy. Fiona's been a very important mentor and friend over the years, and a great support to me in my time here at the University of Edinburgh. Fiona and her partner Georgie Young have also been really generous hosts to my family and I throughout our visit. Fiona, as many of you probably know, has been a driving force behind the establishment of the Chrystal Macmillan Lecture series, and I'd like to thank her for the honour of inviting me to present this, the third lecture. And I also want to acknowledge the other people who make my academic life possible, my husband Robert and two sons who aren't here tonight, James and Angus, who have travelled with me here in Edinburgh, who patiently put up with my distractions with work and support me in many, many ways. And thanks to you too also for coming along tonight. Well, due to the meticulous historical research undertaken by Helen Kay, we're now increasingly aware of Krystal Macmillan's remarkable life. She was one of the first women to graduate from the University of Edinburgh and went on to become an accomplished scientist, administrator, orator and lawyer at a time when women were not expected, or indeed usually allowed, to fulfil any of these roles. Feminist writer and contemporary of Krystal, Cicely Hamilton, wrote of her that she was the right kind of lawyer, one who held that law should be synonymous with justice. Her chief aim in life, one might call it her passion, was to give every woman of every class and nation the essential protection of justice. She was herself a great and very just human being. She could not budge an inch on matters of principle, but she never lost her temper and never bore a grudge in defeat. If only we could all say the same. Macmillan's commitment to justice led to her involvement in some of the most important issues of the day. She spearheaded the campaign in the UK for women's suffrage and pushed for women's equality in international relations. She was passionate about the advancement of equality through feminist activism and contributed to the design of new laws and institutions, including the International Court of Justice, the League of Nations, the International Labour Organisation, just to mention a few. Her actions align very well then with the subject matter of my lecture tonight, which is in many ways a continuation of that story of feminist international activism and institution building. In writing the lecture tonight, I've thought a great deal about the efforts of Krystal and her colleagues who worked together to advance women's rights a century ago. I've wondered what would Krystal make of the ICC and its gender justice mandate, and what in hindsight might her experiences teach us. In thinking about these questions, I've been reminded of two important truths. The first is the need to remember that our continuing efforts to advance women's rights are built on the trailblazing work of our foremothers. That without their strategic vision, political nous, intelligence, determination, and indeed by all accounts of Krystal, stubbornness, we would not be where we are today. At the start of last century, Krystal and her international colleagues laid the groundwork for the now extensive transnational feminist network, which continues to advance gender equality across national and international institutions, including at the International Criminal Court. Amazingly, two of the very institutions that Krystal helped to create, the Women's International League for Peace and Freedom, which will celebrate its 100 years in operation next year, and the International Council for Women, continue their advocacy today, lobbying the UN and national governments on issues related to women, peace and security. The second point to remember is that to assess the achievement of women's rights requires a long historical view. It's important that we remember, while there are moments of profound change in recognising women's rights, such as women gaining the vote, more often the changes arrive incrementally and sometimes slip in unnoticed. There's usually a pattern of advancement and retreat, a pendulum movement with small gains followed by losses and more small gains over time. It's often only by taking the long view that we see how the dedicated work of committed feminist actors has added up to significant shifts in the gender order. It's important to remember this when considering the outcomes of the first decade of the international criminal work for women. The fact that the court includes a gender mandate at all has its antecedents in these early efforts of Krystal and her colleagues to bring to global attention the specific needs and perspectives of women and girls and the importance of gender equality for overcoming conflict and building lasting peace. The real significance of the work of the current feminist activists working with the International Criminal Court may only really be obvious to us, to our grandchildren. Keeping in mind this historical context and the difficulty in making a firm assessment of the court while it's still in its infancy, my lecture tonight aims to ask and answer the question, 10 years on, is the ICC delivering for women? In recent months, the ICC has hit the headlines for all the wrong reasons. In Libya, a militia-run court is refusing to hand over Saif Gaddafi, Colonel Gaddafi's son, to the ICC, despite his willingness to appear. The Côte d'Ivoire authorities are refusing to comply with the first arrest warrant for a female suspect, the former First Lady, Simone Bagbo. While indicted Sudanese President al-Bashir continues to roam the African continent without any states willing to cooperate with the court and arrest him and hand him over to The Hague. Meanwhile, at the UN, we've seen in recent months the Security Council has consistently failed to reach a consensus to refer the Syrian situation to the court. Instead, some legal experts in the US are starting to consider the creation of an ad hoc tribunal acceptable to non-state parties to the ICC, including the US itself, Russia and China. At the ICC itself, cases are proceeding very slowly, and as I'll discuss later tonight, it's only ever handed down one verdict in its first 10 years. Perhaps most troubling of all is that it's under attack for its perceived Africa bias. This has been played out most dramatically in the Kenyan Parliament last month, when it voted to withdraw from the court at a time when cases against its president and vice president are commencing in The Hague. In support of these Kenyan moves, the African Union is holding a summit next week to vote on a mass withdrawal from the court. Together, all of these problems endanger the ongoing existence of the ICC. Next week's African Union summit is particularly troubling. These problems then raise a second question for my talk tonight, that is to consider not only what the ICC has delivered for women in its first decade, but, given the fragile international context in which it's operating, what would be lost in terms of women's rights if it collapsed? In other words, is the ICC worth fighting for? I want to start tonight by setting the ICC in context. Taking a brief look at the history of the establishment of the court, including the effort of gender justice advocates in having women's rights principles embedded in the Rome Statute, which provides the rules for the court. These gender justice features establish the boundaries of what we can expect the court to do for women. They are the yardstick by which we can judge its performance. I then want to consider how well the court has implemented these rules in practice in its first decade and what might explain these outcomes, and finally make a couple of suggestions about how to strengthen gender justice in the next decade and give some reasons why I think we might want to fight to hold on to it as a new global justice institution. So first, to the background to the ICC. The 1990s, as many of you will know, promoted major advancements in the development and articulation of women's human rights internationally. The tone for that decade was set at the 1993 Vienna Conference, which for the first time recognised women's rights as human rights. This was followed then by the 1995 Beijing Conference, which brought women's rights to the centre stage. These events focused international attention again, as Krystal and her contemporaries had done 70 years earlier, on the need to strengthen and enforce women's equality across political, legal, social and economic spheres through the reform of existing and the creation of new gender-just domestic and international bodies. The period was also marked by significant advances in international criminal law, with the creation by the UN of 2 international ad hoc tribunals to address the conflict in Rwanda and the former Yugoslavia. In both these conflicts, sexual violence was used as a weapon of war. Such crimes have always been a feature of conflict, but the scale, the variety of forms of this violence and their detailed documentation in both the Balkan and Rwandan conflicts gave the international community reason to pause. These developments meant that such crimes could no longer be swept under the carpet and ignored under domestic and international law. Drawing on experiences with criminal systems in national states, some women's rights activists remain very sceptical about pursuing women's rights through these emerging legal avenues. They agreed, essentially, with legal commentator Carol Smart, who's argued, quote, that law is so deaf to the core concerns of feminism that feminists should be extremely cautious of how and whether they resort to law. Others, however, saw the creation of these bodies in a different light. They saw it as an opportunity to engage with the law, to develop it in new directions. These actors, operating as critical feminist friends, targeted these new bodies and worked together with sympathetic judges and prosecutors to pursue their objectives. The primary claim of these women's rights advocates working through these tribunals was that historically international humanitarian and criminal law had either entirely ignored women's experiences or, where they were recognised, treated those crimes committed against women, which very often were sexual or gender-based in nature, as less serious, warranting lesser penalties, and only of concern because of their impact on men. For instance, historically, as many of you will know, under international law, and it must be said still in some domestic penal codes, rape has been treated as a crime of honour, an act that was harmful because of the effect that it had on the men who had failed to protect their women, rather than considered as a serious crime against the female victim herself. Further, women's rights advocates drew attention to and sought to challenge myths surrounding women and sexual violence crimes that had permeated prosecutions at both the national and international level. This included that women fabricated charges, were unreliable witnesses, and that crimes of sexual and gender-based violence were harder to prosecute and prove in a court of law. They also challenged existing procedures that discriminated against women in the courtroom, including in trial proceedings where examinations were made of their previous sexual history, the need for corroboration, and the adversarial nature of the courtroom itself, which very often re-traumatised these victims. Working then at the UN ad hoc tribunals, gender justice actors were able to push forward some significant advances in the recognition of women's experiences in war and conflict. They brought to the attention of the tribunal the brutal, widespread and systematic use of sexual violence against women in both the Rwandan and Balkan conflicts. And as a result, prosecutors began to charge and judges became to recognise rape not only as a war crime, but a crime against humanity, a form of genocide and a form of torture. Despite these developments, it was clear, though, that using international law to pursue crimes of sexual violence was still highly problematic. At the tribunals, women witnesses and victims of sexual violence were subjected to harsh and insensitive cross-examination. Prosecutors were all too remiss to include charges of rape, despite extensive evidence of such crimes. And sexual violence charges often failed to stand up in the courts due to the poor quality of the evidence. A general critique of these tribunals too was that the focus was too narrow. Fixed on sexual violence within the conflicts themselves, which thereby did not acknowledge the violence women experience in their ordinary lives, nor other forms of gender-based crimes related to women's social and economic disempowerment, and also missing the way in which sexual violence is enacted upon men. In the mid-1990s, with these ad hoc tribunals in place, the end of the Cold War and a unique alignment of global political forces, the international community agreed that the time was ripe to create a permanent international criminal court with the objective of putting an end to impunity for the perpetrators of the types of atrocities that had come to light during the UN tribunals. Armed with experience and lessons from the tribunals, an international network of feminist legal and political actors came together to form the Women's Caucus for Gender Justice, to lobby those state delegations who were engaged in the creation of the court. The negotiations over the rules of the court took many years, culminating in the 1998 Rome Statute of the International Criminal Court. These negotiations were a very drawn-out political process in which the Women's Caucus and other NGOs played a restricted but nonetheless very significant role. The caucus entered the negotiation process with a set of clearly identified objectives. They included the incorporation of the full range of core crimes against women and a recognition of their gravity, removal of gender discrimination in the application of the law, the provision of adequate personnel and resources for the effective prosecution of gender crimes, and a court with a victims' redress mandate, including provisions for reparations. The politics surrounding these gender justice claims in particular were highly contentious. Some states, backed by the Holy See and other conservative religious supporters, strongly resisted many of the objectives of the Women's Caucus. For a start, they rejected defining gender at all in the statute. They thought this would indicate support for homosexuality. They also opposed the inclusion of certain crimes, especially enforced pregnancy, known to be widely used, particularly in the Yugoslav conflict. These pro-life forces feared that the codification of this crime in the ICC statute would provide a right to abortion on demand in member states. It was, as the Women's Caucus demonstrated, a spurious claim. The final document to emerge from the Rome Conference reflected, as all international documents do, a compromise between these forces, with some of the key gender justice objectives included, others watered down and others left out altogether. Gender justice claims, of course, were not the only contentious ones. There was significant debate also about the prosecutors' independence, the relationship between the ICC and the UN, and the inclusion of victims' rights, amongst other issues. The end result, of course, was a compromise, but nevertheless, the Rome Statute is innovative in a number of significant respects. Firstly, it's a permanent court with the ability to prosecute individuals, not states, as in the International Court of Justice, at all levels, including heads of state, thereby challenging the norm of head of state immunity. It has jurisdiction over the worst atrocities, crimes against humanity, war crimes, genocide, and in future the crime of aggression. And it takes these crimes much further than at either of the ad hoc tribunals. It also establishes the notion of complementarity. This is the political compromise at the heart of the Rome Statute. It recognises that the ICC is the court of last resort, that states only become subject to ICC intervention if they prove their inability or unwillingness to investigate these atrocities themselves. It's also, importantly, a hybrid institution, bringing together in what is quite a tense relationship, retributive and victims redress elements. Its retributive face seeks to prosecute individuals for committing crimes under the statute, while its redress element gives victims rights at all stages of proceedings and does provide a reparations framework. After a great deal of negotiation, it was decided that referrals to the court could come from three directions: the prosecutor, using his or her investigative powers, the UN Security Council, and from state parties themselves. And it's turned out some states have seen that as the right to refer themselves to the court. So the current state of play of the court, there's currently 122 states parties to the statute, but not some of the most important international players. The US, China, Russia, Israel, amongst others, have still not ratified the Rome Statute. The court is currently addressing 18 cases from 8 situation countries, and of these, 4 were self-referrals. So the Democratic Republic of Congo, Uganda, the Central African Republic and Mali all asked the court to take these cases on. 2 came from the Security Council, Libya and Sudan. And 2 came about through the prosecutor's own initiation in relation to Kenya and Côte d'Ivoire. And I should note here that it's the first prosecutor who brought those 2 cases. The second prosecutor has not opened any of her own cases as yet. And as I've already mentioned, in its first decade, the court has handed down 1 verdict in the Lubanga case, which I'll discuss later, which is currently under appeal, and has had 1 acquittal. A particularly important and unique aspect of the court's work is its gender justice mandate. And this does reflect many of the objectives of the Women's Caucus for Gender Justice. The gender provisions map very neatly onto what social theorist Nancy Fraser has defined as the 3 core components of gender justice. The first is the need for social and cultural recognition of women and men. The second is equal representation of women and men in institutions of power. And the third, mechanisms to redistribute resources to bring about economic equality between the sexes. So these 3 aspects are reflected in the Rome Statute in the following ways. In relation to recognition, the crimes that the statute covers are much broader than anything that was available prior to the ICC, including rape, sexual slavery, enforced prostitution, forced pregnancy, and so forth. It also does include provisions on gender-based persecution, taking it much further than the Refugee Convention, for instance. It provides direction to apply and interpret the law without gender distinction, and provides recognition of victims of sexual and gender-based violence. In terms of representation, the statute covers the need for fair representation of women and for gender expertise across all the major organs of the court, the judiciary, office of the prosecutor and the registry. And it also allows for the representation of victims and civil society actors in the proceedings. In terms of redistribution, the court is very innovative here. Through its reparations regime and the rules of the Trust Fund for Victims, which the Rome Statute establishes, there's a specific focus on the need to include women and victims of sexual violence. So in this next section of my lecture, I want to use these three categories of recognition, representation and redistribution, and to run through where I see the main points of success for the court in its first decade, and also where its main gaps remain. I want to do this by giving you first a bit of an overview of what's happened, but then delve more deeply into the first case that the court has dealt with in relation to Lubanga, to demonstrate to you how these tensions are developing in practice. So, first to the good news. There's been a growing recognition and representation of women and girls in the work of the court, which is evident in the following ways. This graph here, I think, shows it most starkly, that sexual violence, crimes against women and girls are increasingly being investigated and included in the charges that are being opened by the Office of the Prosecutor. 70% of the cases currently before the court include these charges. Not only that, they have been included across all the categories of crime: crimes against humanity, war crimes and genocide. In 2 cases currently before the court, the majority of the charges relate to acts of sexual violence. There's also been some evidence that the charging strategy is developing a growing understanding of how sexual violence is actually experienced during periods of conflict. To date, sexual violence crimes have been charged not only as rape, but as serious bodily and mental harm, as sexual slavery, as a form of torture, a form of persecution, and outrages on personal dignity. The court has also established procedural rules which recognise the specific harms suffered by victims of sexual and gender-based violence, including courtroom processes such as in-camera evidence, the appointment of skilled gender justice representatives, as well as the provision of psychosocial support services for these particular victims. A really significant and staggering breakthrough in terms of representation is the number of women judges on the bench at the court. 60% of the current bench at the ICC are female, and this stands in dramatic and stark contrast to domestic courts and other international tribunals. The International Court of Justice, for instance, one of those organisations that Krystal helped establish back in the 1920s, has only ever had 4 female judges, and all of those appointed, I think, in about the last 15 years. The UN ad hoc tribunals has only ever had 2 female judges at any one time. This is an important development for its own sake. Whatever the political, and by that I mean here feminist, orientation of these women judges, it sends a message to the world that women are equal citizens and have both the right and the capacity to adjudicate on matters of major international significance. But importantly, as the literature on gender in legislatures tells us, it's not just the number of women that matter, but whether the women and men within an institutional setting are committed to gender equality goals. Evidence shows that when women with a sensitivity to gender justice are working with sympathetic male champions, the chances of advancing women's equality is much greater. And importantly, the ICC includes rules that to have judges with expertise in sexual and gender violence. Based on the available autobiographies, it transpires that the majority of women indeed do have this background, but interestingly, none of the male judges. The predominance of women with these backgrounds on the bench provides a much greater likelihood, but of course no guarantee, that the sexual and gender violence crimes included under the statute will be understood and interpreted in ways which potentially advance gender justice. And this does appear to be borne out in practice at the ICC, as I'll explain in relation to the Lubanga case. Significant too in terms of representation is the appointment in 2012 of Fatou Bensouda as the ICC's second Chief Prosecutor. Prosecutor Bensouda has made it clear that issues of sexual and gender-based violence will be a priority in the 7-year term that she holds, and that she intends to make sure that these crimes are given attention. And I hope you can see in that slide that she's actually holding up a handwritten pledge here to fight gender crimes through my work as a chief prosecutor as the ICC. I don't know who made her do that, but it's a wonderful picture to have. We can hold her to account. The prosecutor is currently finalising the offices of the prosecutor's first detailed gender policy. It's obviously contentious. It was due out last November and we're still waiting. But the development of such a policy itself sends a very strong signal that these issues are indeed being taken seriously inside this important organ of the court. A third important advance in representation has come about through the use by gender justice civil society advocates of the ICC's rules of engagement, if you like, through the provision of amicus curiae briefs or their expert submissions. The Women's Initiatives for Gender Justice, who took over from the Women's Caucus, has been granted leave on several occasions now to provide submissions to the court, providing important additional contextual information about the extent, nature and use of sexual violence in conflict settings, which has had an impact on the ICC's deliberations. It can also be argued, on the positive side of the ledger, that the redistributive element of the gender justice mandate has been advanced through the ICC. The Rome Statute Trust Fund for Victims, which has responsibility for managing any reparations orders for the court, as well as its own assistance programs, has put in a major effort to ensure that all of these programs include a gender focus. The work of the Trust Fund in relation to reparations is also possibly about to be triggered as a result of the Lubanga case. There is a negative side to the story, however. As Krystal and her fellow advocates were well aware, establishing rules to advance women's rights does not automatically translate into their adoption in practice, and so it's the case here at the ICC. In the court's first decade, there have been a number of significant gaps in the implementation of the gender justice mandate of the court. The most significant of these are, first, in terms of recognition. It's important to note that the charges for sexual and gender-based violence are still very vulnerable to collapse at the pre-trial and trial phase. So far, from starting from that 70%, we see 50% of all those charges being dismissed before trial, and none of these have made it to the verdict stage. That's not saying much, of course, given we've only had one verdict being handed down. This collapse, it has been argued, is a result of two factors. The first is an ongoing problem of weak and insufficient evidence being collected by the prosecutor, and I am going to emphasise the first prosecutor, especially an over-reliance on open source evidence coming forward from NGOs and so on, rather than that important detailed work that needs to happen with witnesses and other forms of evidence. In their decisions, judges have been absolutely scathing in their criticism of the office for evidence being insufficient, very poorly pleaded and incapable of supporting the charges sought. But the problem does not all rest at the door of the prosecutor. The judges too have contributed to this poor record. In a number of cases where the prosecution has advanced reasonable evidence, judges continue to adopt a narrow reading of the law, indeed narrower sometimes than that of the UN ad hoc tribunals, in recognising experiences of sexual violence. For instance, the court refused to accept, in line with rulings from the Rwandan tribunals, that forcing women to undress in public in order to humiliate them constituted a crime of another form of sexual violence. In another case, the chamber dismissed an attempt to link a charge of rape to a charge of torture in order to recognise not only the harm of the rape to the victim herself, but also the harm suffered by the family in being forced to watch the violence. Such a link was recognised at the Yugoslav and Rwandan tribunal. In one of the Kenyan cases, forced circumcision and penile amputations were dismissed as sexual crimes, reflecting a very limited understanding of the gendered nature and varied experiences of sexual violence. There are other problems that exist outside of these charges and prosecutions. The Office of the Prosecutor also appears to have paid little attention in its complementarity investigations to establish what action, if any, a state is undertaking to address reported crimes of sexual violence. My co-authors and I have called this the gender justice shadow of complementarity. In our research into the cases of Colombia and Guinea, we show that although the Office of the Prosecutor recognised that sexual violence was a core crime committed in both these situations, its investigation had seemingly paid almost no attention to whether and how these states were addressing these crimes. In other words, what we're suggesting in this work, that crimes of sexual violence continue to be of secondary concern and are certainly not considered adequate grounds on their own yet to challenge state sovereignty under the Rome Statute. A problem also exists at the ICC with representation of women across its victims redress system. Substantially fewer women are involved in the ICC's outreach programs or come forward to register as victims with the court. And in some cases, such as in relation to Darfur, there are 70% fewer women engaged and registering as victims. The disparity of the number of men and women engaging with this aspect of the court's work has a knock-on effect. It leads to problems of recognition. Without women's voices in the courtroom, international criminal law is left only with a very partial understanding of women's experiences of war and conflict. It also potentially sets up problems for the court's redistributive functions. It could be the case in future that those not registered as victims in a particular case will have less access to any reparations decisions made by the court. There is also an ongoing overarching problem at the ICC where one of the key objectives of the original women's activists have clearly not been met, and that is in the lack of resources and budgetary limitations on programs to advance gender justice. The outreach and victim services of the court are severely underfunded, affecting all victims, but especially women who often lack the literacy and other skills to engage with the court, and who are most likely to experience sexual violence and require sensitive, time-consuming and resource-intensive services. These resource constrictions are a result of decisions made by the Assembly of State Parties, who together provide the funds for the court. It could be argued that state inaction and deprioritisation of gender justice concerns domestically are now carried over and reflected through the Assembly of State Parties internationally. Well, this overview of all areas of the ICC's work gives some indication about the very mixed outcomes for women in its first decade. The partial and tenuous nature of the outcomes is even more obvious if we set it in the context of a particular case. So now I want to go on and talk about this Lubanga case, the first to come before the court. So just to give you a very brief snapshot. The ICC's first case commenced in March 2006 when militia leader Thomas Lubanga was arrested for crimes of enlisting, conscripting and using child soldiers in the Democratic Republic of Congo. His trial began in 2009 and ran for 3 years. In 2012 he was found guilty of all 3 charges and given a 14-year sentence. From the outset, however, there was a major problem with the Lubanga case from a gender justice perspective. Although evidence had been gathered by a range of reliable sources, including by the UN and some officers within the prosecutor's office themselves, that sexual violence had been committed on a massive scale as part of the conflict in which Lubanga was involved, the then prosecutor, Luis Moreno Ocampo, declined to include any such charges in Lubanga's indictment. He also had the authority at various points in the proceedings to expand the charges, but he consistently refused to do so. At each stage of the proceedings, however, at the pre-trial, trial itself, the verdict and sentencing phase, women's rights activists worked very hard to make up for the prosecutor's omissions and to bring a gender justice lens to bear on the proceedings. At the pre-trial phase, the women's initiatives unsuccessfully sought to have the court hear their submission to have the prosecutor reopen the charges to include sexual violence. And even though they were unsuccessful, their efforts did bring attention to this issue. During the trial, the women's initiatives kept up attention on the issue through its advocacy work and was supported in its efforts by one of the 3 trial judges, Justice Elizabeth Odio Benito. Justice Benito had previously been a judge on the Yugoslav tribunal, where she'd developed quite a reputation for asking difficult gender questions that got her into trouble in more than one case, and a trait that she continued here at the Lubanga trial. Judge Benito pursued her concern for gender justice in numerous ways throughout the case. During the trial, she worked very hard to draw out evidence through her questioning about the explicit sexual and gender-based nature of the experiences of child soldiers. This questioning was persistent and detailed on issues related to sexual violence and the presence of women and girls in the armed forces. Through her questioning, the court came to better recognise the different treatment of boy and girl soldiers in the DRC conflict and the way sexual violence was used, particularly in relation to the girl soldiers, as a feature of the conflict. Further, during the trial, Judge Benito also supported a submission to recharacterise the facts of the case to include sexual violence, especially sexual slavery. This move was supported by the majority of the trial chamber but ultimately overturned on appeal. The combined efforts of Judge Benito and women's rights actors outside the court came to have an impact on the prosecution's position during the trial. Although Prosecutor Ocampo maintained his unwillingness to add sexual violence charges, he began to argue, rather ineptly, it must be noted, in his submissions that sexual violence should be seen, in his words, as intrinsic to the crimes committed by Lubanga and taken into consideration as an aggravating factor in the verdict and sentencing. This was, as one commentator put it, an attempt to camouflage the gaping omissions in his own indictment. It's likely that alongside the pressure from the women's initiatives and Judge Benito, that the then Deputy Prosecutor, Fatou Bensouda, also influenced the prosecutor's position to start to include sexual violence as a feature late in the case. So when it came to the verdict and sentencing, the majority judges flatly rejected the prosecutor's attempt to include sexual violence through what they saw the backdoor route. In the judge's view, the failure of the prosecutor to include sexual violence charges meant that these crimes could not be considered in their deliberations in defence of defence rights. However, again, at the verdict and sentencing stage, Judge Benito played a critical role in advancing gender justice by producing 2 dissenting minority opinions. She took up the prosecutor's case, arguing that sexual violence was embedded in the crimes of which Lubanga was accused, and agreed it should be understood as intrinsic to the element of the criminal conduct. She also argued that to exclude sexual violence from the interpretation of crimes would be discriminatory on gender grounds, because there was a clear differential impact on the treatment of boys and girls. At the sentencing stage, Judge Benito again dissented from the majority, strongly disagreeing with her fellow judges in not seeing sexual violence as relevant to the sentencing. She argued that Lubanga's punishment should include consideration of the experience of many victims of sexual violence because of its transgenerational effects. It's important to note that Judge Benito experienced a strong backlash throughout the trial in handing down these dissenting judgments from those who perceived these actions as overtly political. In the view of critics, Judge Benito was seen to be construing the law too widely and wavering too far from an impartial judicial analysis. This was a very familiar critique to Judge Benito. She'd come under very similar attacks at the Yugoslav tribunals from constituencies who rejected her feminist interpretation of the law. At the reparations phase of proceedings, the whole chamber adopted a more sympathetic approach to gender justice concerns. This is triggering that victims' redress side of the court's mandate. In their decision, which reflected the many civil society submissions that the bench had received, all three judges agreed that the reparations principles must take into account the needs of all victims, including those of sexual and gender violence. Reflecting specifically the submission of women's initiatives, the judges made the point that any reparations principles needed to be devised in a way so as not to reinforce the gender status quo that existed prior to the conflict in the DRC. Instead, they indicated the need to make reparations transformative, breaking down hierarchical relations between men and women in this post-conflict setting. So based on this overview and assessment of the ICC's first trial, let's return to consider what has the ICC delivered for women. In the first decade, there's been an effort by some judges, the second prosecutor and outside advocates to use the rules of the Rome Statute to advance women's rights, and with some success. The presence of feminist-minded actors and external pressure from women's groups has led to some of the new rules being used some of the time to advance gender justice claims. The significant number of women on the bench with gender expertise, the increasing number of charges for sexual and gender-based violence, and the first reparations decisions are marks of greater recognition, representation, and a measure of redistribution. Judge Benito's dissenting opinions and probing questions in Lubanga show that even where a case ultimately produces negative outcomes in terms of the verdict and sentencing, interventions by feminist actors within the court can contribute to a deeper understanding of the gender dimensions of the crimes. Indeed, it is these dissenting views that may well have the greatest impact on the future work of the court, as well as other international tribunals and possibly at the domestic level as well. But we've also seen, as I've explained, some very concerning trends, including retrograde judicial decisions, poorly investigated sexual crimes, problems of access and resources, which have plagued the court in its first decade. Another more general problem at the ICC, one that was highlighted in relation to the UN ad hoc tribunals, is that where advances have been made, they've largely focused on the recognition, representation and redress of crimes related to sexual violence during periods of war and conflict. I don't want to suggest that these developments are unimportant, but they are partial. They do little to assuage what we might call women's ordinary experience of sexual and gender-based violence, and nor do they address the deeper social, cultural and economic disruptions that come with war and conflict that have specific gendered effects for men and for women. So, what's going on here and how might we make sense of this? In part, what we see, I think, is another case of what Fiona Mccoy has pointed out in her important work on the Scottish Parliament of remembering the old and forgetting the new. In the first decade, we've seen examples of the Office of the Prosecutor, judges and other actors at the court reverting back to old gender-biased ways of understanding the law, despite the presence of new, innovative, formal rules. This highlights for us the legacy and tenacity of informal gender norms. These norms that have long been embedded in international and criminal law have been carried over, or have infiltrated, if you like, the ICC and have partially influenced the practice at the new court. Importantly, these gender norms have been evident not only in the actions of the court, but I'd argue more importantly in its inactions. That is, where it has not pursued particular charges, where it has not gathered essential evidence, and where it has not remembered earlier legal judgments that had a more advanced understanding of the gravity and harm of specific gendered criminal conduct. Having new formal gender justice rules embedded in the statute is an important development, but clearly these rules on their own are not enough to advance women's rights through the ICC. In going forward into its second decade, I want to suggest 3 interlinked steps for advancing gender justice at the court. The The first step the court could take would be to deepen links between insider and outsider gender justice advocates. As this initial decade has shown, it's at those moments when these two sets of actors are working together at the court that it has delivered for women. This means encouraging the broader transnational women's movement to pay more attention to developments at the court and to engage with it at those moments when critical decisions are being made. Supporting efforts on the ground to gather evidence, to monitor and to report on local efforts to hold perpetrators to account, and disseminating information about the work of the court are examples of practical measures which this movement can use to support the gender justice mandate of the ICC. It also, of course, means encouraging more gender justice-minded legal experts, judges, prosecutors, defence counsel, administrators, both men and women, to follow in the footsteps of Judge Benito and Prosecutor Bensouda to seek admission to the court. And I should note here that there are limited terms in these appointments at the court. So when one moves on, if that is the only feminist there, you lose that voice within the ICC. The second step forward is for actors inside the court to make better use of the rules at their disposal. As feminist legal scholar Catherine McKinnon has noted, the Rome Statute does contain within it radical, transformative potential. Finding ways to trigger this potential is yet to be fully explored. An obvious step is to build stronger cases for prosecuting perpetrators in The Hague and encouraging judges to read their gender mandate widely. But perhaps more importantly, there's a need to bring more attention to how the complementarity principle can be used to advance gender justice at the level of the state. Both court and NGO actors must strengthen their efforts to encourage states to ratify the statute, and then once they do, importantly, implement the advanced gender justice rules into their own local penal codes. Bringing sexual and gender-based violence provisions up to a standard equivalent to the Rome Statute within the domestic setting will surely be a more significant boost to addressing the harms experienced by women in conflict than a few high-profile prosecutions at the ICC. The final step is to better coordinate the work of the court with both its redistributive and redress elements with other international and local efforts to advance gender justice. The ICC has the capacity to operate as an important link in a chain of global gender justice, but I would argue it's yet to fully realise this role. Exploring new avenues for engagement between the ICC and other women's rights initiatives, including local peacekeeping efforts, transitional justice mechanisms, UN activities, especially its Women, Peace and Security mandate, is essential if the ICC is to help tackle not only impunity for crimes of sexual violence, but the broader economic and social harms that women experience as a result of war and conflict. So to conclude then, I'd like to briefly return to speculate on what Krystal Mcmillan would make of the ICC in its first decade and suggest why, in the face of its current challenges, I think the court is worth fighting for. Given her own commitment to using the international institutional arena and the law to pursue justice for women, I think Krystal would support the establishment of a permanent international criminal court. As a feminist institutional designer, I think she'd be impressed by what women's rights advocates were able to achieve in terms of embedding gender justice in its mandate. And I would hope that she would take some pride in the foundations she and her colleagues laid many years earlier to make these developments possible. I'm also confident that Krystal would recognise the contestation that's taking place within the court to have the gender mandate of the Rome Statute enacted in practice. Krystal and her contemporaries encountered numerous forms of resistance in their campaigns to embed women's rights in the laws and policies of the day. Sometimes they succeeded in overcoming this resistance, but at other times they were forced to accept compromise or indeed a loss. Krystal's response to these setbacks was not to walk away from the challenge, but press for greater accountability for women's rights through the reform of existing institutions and the creation of new ones. There are important lessons here for pursuing gender justice at the ICC in the next decade. After 10 years in operation, now is the right time for the ICC to critically reflect on its performance, to think about new strategies for advancing gender justice into the future. It has the tools it needs to do this in the Rome Statute. What it needs is an ongoing stream of dedicated actors working within and without, willing to enact these rules. Their task is to keep pressure on the court to remember the new and forget the old, and like Krystal, to be tenacious and keep calling the ICC to account on its implementation of its gender justice mandate. Given these partial advancements in gender justice at the court, should we care if the African Union vote endangers the court's existence? And if, as more likely, it does survive, even in a diminished form, should we side with those who are sceptical about the law as a venue for women's rights and abandon the ICC project altogether? Well, in my view, the ICC is imperfect, there's no doubt about that. But it does offer an unprecedented framework for advancing women's rights, key aspects of which are gradually being put into place. The full recognition of the court's gender justice mandate is likely to arrive in small, highly contested, incremental steps. But as a whole, it does have the potential to be transformative in terms of reconfiguring the gender status quo. But as with Krystal's work, we may not see this transformation clearly for many years yet. The ICC still has considerable room for improvement in addressing women's rights, but we would be worse off without it. The AU's vote is important on many levels, including reminding us that for the ICC to combat impunity for sexual and gender-based crimes, amongst others, the court and the international community more broadly must not just focus on Africa, but pay attention to wherever these happen globally. We must acknowledge that gender injustices are an international problem that require an international solution. Thank you.
Thank you for a wonderful lecture. I'd just like to introduce Professor Christine Bell, Professor of Constitutional Law here in Edinburgh and a leading expert on transitional justice herself, will give a brief response to the lecture. Christine.
Thank you. I'd like to thank Louise very much for her lecture. I think it was... I find I'm still thinking about it and trying to process it, so it's going to be quite difficult to respond. And I'd also like to add her thanks to Fiona Mccoy for involving me, because it really is an honour to respond tonight. And I think, and I suppose also I just would like to say it's lovely coming to Fiona's events because there's always such a crowd of faces that you see and have been impressed with in other spheres of life. I really like the way Louise was able to draw such a direct trajectory from Krystal Mcmillan's work, and in particular the Women's League of Peace and Freedom, which has remained amazingly central to international legal developments, and in some senses, even hearing tonight about that period at the turn of the century in the Paris Peace Treaty, in some senses traces a direct line that jumps to this age and some of the processes that emerged in the 90s. And in fact, the treaties themselves and the votes that took place after the peace treaties were one of the first times that women voted in many of the countries around the self-determination decisions that were made. So actually that time was a period where transformative potential was, in some sense, harnessed in lots of curious ways. And so in some sense, I think both Louise's presence here tonight and also the topic of her lecture really made those connections in a very powerful way. And in coming to respond, I just wanted to really acknowledge and touch base with three things that struck me where there seemed to be, in ways, a curious pairing of the positive and negative. And I find these are the things that I find myself pondering at the end of the lecture. And so just to say each of these three pairings, the positive and the negative, if you like, one side and the other side. The first is in the acknowledgement and the power of mobilisation, the trajectory of the International Criminal Court, and the concerted efforts it took over domestic and international actors, and almost forging at the same time new forms of transnational cooperation, new forms of praxis and norm generation. And in some senses, I think, a triumph of decades of feminism in many ways. And it's interesting to see how those, and hear tonight, how those new relationships between Women's Initiative for Gender Justice and the court have continued to play out. And in fact, to see Louise's recommendations at the end, where she says it's those moments of insider-outsider connection that really were transformative insofar as the ICC has responded to the challenge and that they should be built on. But I suppose on the other side, the negative lesson is that some of the gaps are just really striking and shockingly graphic, and in a sense almost unbelievable. And I suppose my hope would be that in retrospect we might see this as a 10-year aberration of the court. The court was a new institution. I think there is a general consensus that many of the actions of the first prosecutor were characterised by lack of strong process values, lack of political astuteness, and I think there are gaps in the gender perspective, and I know not all the responsibility lies at his door, but I think they did create a broader problem, and in ways what I would hope is that the ICC starts here, but of course it starts here as an undermined and fragile institution with its job made harder, not least because there is now the groundswell of African opposition at an institutional level and a very powerful institutional level. My second positive, I think, is the really affirming story, both from in the presence of Krystal Mcmillan and actually Justice Benito, of the power of individuals to change things by the nature of how they approach, how they do their job, and the creativeness and imagination and connectedness with which they do that. So one woman can make a difference, and I suppose I would say to students here and to the academics, take note. But we also need to be aware that those of us that are not in the high-profile roles of Justice Benito need to think carefully about how we do support those women, because those places can be quite lonely places to be. And they take significant risks in many different senses when they stand there. And on the other hand, what was also very striking was the fact that just getting women into institutions isn't enough. It's been a really big dynamic in the peace agreement field and the UN Security Council Resolution 1325 that getting women into positions as chief negotiators, into peace talks, in as gender advisors is significant and seen sometimes, I think, as a gain in itself. And yet it was striking to see all those women and hear the statistic of 60% and hear the narrowness of some of the decisions, which were so shocking. You know, thinking particularly that how can enforced circumcision not be a gender crime? It seems astonishing, really. My third and final negative is, in some senses, the immense importance of the ICC. And I think that really came through tonight, that symbolically it's hugely important. And I think in some senses when academics, often sort of from Western liberal democracies, have been critical of the ICC, they fail to recognise that when you're standing in a difficult position in a conflict and where there's very little that is ever going to bring you justice, the pure symbolic value of something out there that says that it's going to do that is exact fact, regardless in some sense of how well it's able to deliver, something that maybe affirms you and helps you go on at a day-to-day level. So I think the immense importance of the ICC symbolically, it's also one of the few institutions that has a power to call states and heads of states to account. I think it has also had a significant influence on domestic law, both transitional justice mechanisms at the domestic level and also right down to countries like in Northern Ireland, which will never ever, because of complementarity, be near the ICC. And it also has capacity to impact on conceptions and provide that radical transformative edge. I mean, one of the more controversial elements that has been pushed in international criminal law has been the notion of changing burdens of proof regarding consent in rape cases where hostile or contained environments are present. And in some senses, in a situation where all rapes at the domestic level because of DNA evidence are now viewed as forms of date rape and defended as such, that kind of trying to reconceptualise around hostile environment has immense provocative potential. But counterposed against that, I suppose, is the fragility of the ICC's fragility and, in a sense, its unimportance. And I suppose the most striking statistic we heard tonight is really, one concluded conviction. And again, when you think of the scale of violence in even one of these conflicts, and when you see the huge resources, both in terms of finances and the court, but also the women who testified, the women who came under threat for that, the women who told their stories, first of all to lots of strangers and then maybe to unsympathetic lawyers and went through all sorts of forms of cross-examination. There's been a tremendous cost for what seems like a little result. The US and Sudan have not signed up. African nations now see it as unhelpfully an African mechanism which infringes sovereignty and are currently trying to set up alternatives. And I think this is in ways really why, and where I'd like to end, why Louise's research and other efforts regarding the ICC are important. Louise's lecture and her wider work has stood within the tradition that I think she identifies as critical friendship. And this is really, really important, not just for its own sake, but to create that space of critical friendship, which is a really difficult space, I think, and a difficult zone to carve out. The ICC, like many institutions, due to its big ambition and its low delivery, perhaps more than most, attempts two responses. And the first is to extensively buy into its importance and the importance of gender gains precisely because of its symbolic value. And early engagement with international law by feminists, I think, was very concerned about norm production, producing laws and making sure issues such as sexual violence were included. And more recently, we've seen almost the counter side of that response, a more critical, reflective term, some of it turning very critical, questioning whether norms are useful, whether the project of normative and institutional engagement has any value, or is in fact, as some say, even a new form of feminist power that itself has a corruption. And this plays out, I think, in what I find is my ambivalent response to ICC that I think many people share. We really, really want it to work, and we really want it to work for women. And the mix of reasons why we want that are very broad. But it is flawed in so many ways that it's almost too easy to be critical of it. And one feels you fail as a feminist and an academic if you aren't prepared to engage in that criticism, because it's also about pushing for the transformative potential. And in fact, I think this is what Louise's lecture and her work more generally brought out really beautifully, that of course both are true, and critical friendship and attempting to navigate what critical friendship looks like is one of the few ways to respond responsibly. I think Louise's lecture was in the best of that tradition and a really good example of how feminists can walk this line. And I look forward to seeing more of her work and seeing where the court goes in what I really hope is a new and positive era. Thank you.